Hello and welcome to State of the Economy, a show that connects you with key policymakers and thinkers. Today we have with us a very special guest, Mr. Ashok Chawla, who is Chairman of Competition Commission of India. The Competition Commission in India is about 10 years old and it is still evolving. In recent months and years, it has handled a lot of issues which have come to the Commission in regard to abuse of dominance in various sectors. So today we'll discuss some of these issues and other mandates that Mr. Chawla has handled before he took over as Chairman of the Competition Commission. Welcome to our show, Mr. Ashok Chawla.
Thank you.
I will start with a broad question as to where do you think the Competition Commission today stands? It has evolved over the last 3-4 years, especially after it got powers some years ago. Although the Act itself is, it dates back to 2003, as you said, but the real powers came only about 2-3 years ago. Now, subsequent to that, a lot of debates we have witnessed as to the role of the Commission or whether is the Commission exceeding its brief in certain sectors. Now, where do you think the Commission stands today?
Yeah, just to cover the factual ground, partly which you have mentioned, the Act is about 10 years old, but it was amended in 2007, and the Commission as such was set up in 2009. So as a body, we are about 3 years old. The provisions relating to dominance, relating to anti-competitive practices were put into effect from May 2009. But the merger and acquisition provisions of the Act were enforced from June 2011. So some part of the Act 3 years old, the rest about 1 year old. The body is slowly finding its feet. We are looking at a number of areas and sectors on our own. Some cases were transferred to us, so that process is on. And we've handled in the last 1 year or so about 60 proposals for mergers and acquisitions from various companies which needed to come to us as per the provisions of the Act. And we have decided and put in our regulations that where there is no prima facie effect on competition that we perceive, we will decide those cases within 30 days. And we've decided all these cases where there was no likely impact, adverse impact on competition.
So this is the first time you set this time limit for deciding the case.
The time limit was decided before the provisions got enforced, but that's not in the Act. So therefore, that's a self-imposed discipline which the Commission has taken upon itself. And we've adopted it specifically because there was a certain amount of anxiety and misgiving in the corporate sector when these provisions were getting enforced as to whether this new body and this new regulator will stand in the way of logical consolidation and inorganic growth.
Yeah.
So we wanted to clearly send out the signal that where we do not perceive any adverse impact on competition, we are not going to stand in the way.
It's very interesting, you talked about how the corporate sector is always a bit suspicious of whether such bodies will come in the way of inorganic growth, consolidation. This is the experience in the West too. And there has been debate in India whether, this was the position about 6-7 years ago, where economists and other intellectuals, they used to ask this question whether is India really ready to have a competition commission which checks abuse of dominance or which checks organizations or corporates which are building scale, because scale is generally is conflated with monopoly. Scale is seen as scale leads to abuse of monopoly. So that's the logic. Now, do you, in your experience, say compared to say 7-8 years ago, do you see more instances of abuse of dominance in high growth sectors like real estate? You had some cases in the real estate sector, consumer cases, consumer complaints, say in aviation, in other high growth sectors where there are M&As happening. What's the sense that you get?
See, firstly, businesses anywhere whether it's India or any of the other economies, businesses don't like regulators. They don't like regulators, they don't like tax people.
Yeah.
Having said that, the evolution of the Indian economy which we've seen, the private sector got a major role to play after 1991.
So it's been 20 years now. Yeah.
So there was the fact that there was a lot of entry of private businesses into areas and activities which they were earlier either barred from, or there was high degree of physical regulation. So that process took about 10, 11 years. And therefore, in the early part of the century, there was a feeling that whether the growth dynamics has reached a stage where we need a competition law or not.
Okay.
That debate, I think, got settled.
Yeah, it got settled.
In the sense that we are now at a stage when we've reached 2011, 12 and so on, where the corporate sector is now about 20 years old. There's a lot of business activity which is taking place. In fact, the process of consolidation
Has happened in several sectors. Yeah.
has happened in several sectors and will continue to happen, because the overall degree of fragmentation in Indian business and industry is still quite high.
Still quite high.
So the logical corollary is that we are going to see a fair amount of consolidation and restructuring of businesses to take the advantage of scale and economies of size. Now, where scale ends and where the probability
Of abuse of dominance begins.
misuse of the scale and size comes in is precisely where on that cusp the competition commission or bodies which watch the market.
So it's a
come
judgment
in.
call. Yeah.
It's a call which is basically based on judgment, partly on facts, partly on numbers, not entirely on numbers, because it's basically what the corporate entity is doing and how it is behaving in terms of what its size is. So it's not size per se, but the adverse impact or the abuse of that size.
Yeah, that's what, Mr. Chawla, I wanted to come to this point which you just made. It's not necessary that size alone leads to abuse of dominance, not even dominance, general abuse which affect consumers. For instance, the cement sector, I keep hearing complaints that the cement sector, fragmented though it is, there's always still this suspicion, lingering suspicion that cement manufacturers are, they are in concert to set prices. So is the case that we see in steel. Now we're witnessing this in oil. You made a statement on how is it that Indian oil companies always set price together. Why can't they? That obviously means that they talk to each other, set prices. And now how do you see some of these price setting, coordinated price setting activities?
Well, it depends, as you said, on the structure of the market and the number of players. Where the market concentration is relatively high, in the sense that the market is more oligopolistic, then the probability of those entities coming together in times of difficulty from their point of view, difficulty when the demand is lower than the supply, then the probability is higher. Then you will see the kind of thing that we see in various sectors. And I wouldn't like to go into individual sectors because some of these we are seeing at this point in time from the judicial point of view. But there the probability is higher. And very often what one finds in those cases is that there is a gradual decline in capacity utilization when they work together to ensure that either prices are coordinated or the quantum of production
Is
which they
managed.
which they put into the market is managed.
My experience is that in many sectors, a broader point, we do see a certain oligopolistic tendency. There are 3 or 4 players who control, say, 80-90% of the market. Do you also get a sense that in many sectors this is happening in India? In that sense, we don't have really a perfect competition situation in a classic sense,
Perfect competition, of course, is more in the textbooks, but while there would be some sectors where the concentration is high, but I would still say that overall the degree of market concentration and therefore substantial market power with 1 or 2 entities is not that high in many activities. And this is a legacy that we carry from the post 1991 opening of the economy. Now, it's possible that this situation, and it's very likely I would think that this situation may change over the next 10 or 15 years, but it's going to take some.
As more consolidation happens. We will come back to this discussion, but after a small break, please don't go away and keep watching Rajya Sabha television. Welcome back to State of the Economy. We are having a conversation with the Chairman of Competition Commission of India, Mr. Ashok Chawla. Mr. Chawla, you rightly said that we are not seeing very many instances of oligopoly or abuse of dominance thereof as of now. But as more consolidation happens, as more inorganic growth takes place over the next 10 years, you will see more of it, right? So is the Competition Commission of India preparing for it in terms of suo motu research, or what is the kind of infrastructure do you have to detect such possible abuse of dominance as you go along?
See, for one, the act that we have, which Parliament has given us, is very, very robust. It's based on best kind of international practices. The penalties provided therein are sufficiently high, and as we pass out certain judgments and decisions, I think that's the first kind of signal which the market will get. The second thing is we have in the Act a provision for a Director General, which is the investigative arm of the Commission. That's a specialized body, so the investigator is different from the judicial body or the judicial bench. They do the groundwork. In whichever cases we decide that a detailed investigation is required, they go into it. They have people from various disciplines in that organization, and they produce voluminous reports. They meet people, they look at the oral evidence, they look at the papers, they look at the market documents, movement of prices, production, and tell us what the offenses are which they are supposed to have committed. Based on that, we hear the parties. And
so this is a constant process, you're saying?
This is a constant process for which I believe that the Commission is quite well equipped. There is a small lacuna in the Act, according to us, which does not allow the Director General to make searches and seizures. And we have requested the government in the forthcoming amendments to the Act, as and when they take place, this should be taken care of, which will further strengthen the hands of the investigative body and therefore of the Commission.
Seizure of documents, evidence, etc., right? So essentially, what you're saying is that you need more investigative powers.
That will help.
Yeah. Now, coming to some of the recent debates, there seems to be a conflict developing, as it were, between the mandate of the Competition Commission, which you have described as a generalist, as opposed to the mandates of sector regulators who are specialists in their domains. And you've also given some interesting explanation as to what is their turf and where you come in. They handle ex ante issues and you handle ex post. Now, can you explain to us in greater detail as to how do you create a framework where you are in sync with and in harmony with sector regulators such as TRAI, Telecom Regulatory Authority of India, the RBI, which regulates banking, or the shipping sector. In some cases, of course, we don't have regulators, the government. So do you deal with the government officials who regulate those sectors? So how do you go about this task? It's a very interesting combination of things that you have to do.
Well, essentially and originally, these are all tasks which the sovereign performed.
Yeah.
The original regulator is the sovereign.
Sovereign, yeah.
And the sovereign over the years has decided as a matter of policy to distance some of these activities, give them out to regulators, and that's why we've had over the years various regulators. And here I'm not talking of the Reserve Bank, which is an original sort of regulator, and more from the point of view of the monetary policy and so on. But as these other regulators have come in broadly, and that's what applies all over the world, that they look at their sectors, they look at technical issues, they look at issues of licensing, they look at
Pricing.
they look at economic issues relating to pricing, relating to maybe what will be the method of auction and so on and so forth on whatever they give out. So either they decide or they make recommendations to the government and the government decides. They do not look at what is the behavior post the activity being started or being done by a corporate entity, because that's not really part of their mandate. It was not there.
By then the horse has bolted, as it were. So,
Well, the economic activity has started, and they would have taken certain decisions thinking that this is how the scenario will unfold. But how it actually unfolds, what really the corporates do, whether they behave in the manner that they were expected to behave or not, whether they combine together and hijack the market,
that is clearly your mandate.
that has to be looked at by somebody which is mandated to do that. And that is what the competition commission here and the competition authorities in other jurisdictions are mandated to.
So, which means by definition, you are supposed to look at mergers and acquisitions and how they lead to possible concentration of market in just a few hands, right?
That's right.
But in some cases, mergers and acquisitions are, for instance, under the new amendment to the banking laws, mergers and acquisitions have been put under the RBI domain, and similarly, there is a move to put mergers and acquisitions, for instance, in the telecom sector, it is not even with the sector regulator, it is now more with the ministry, DOT. Now, these things have to be harmonized, right? They have to decide whether, somebody has to decide, the cabinet perhaps, even parliament, that M&As possibly should be given to CCI. So, even if you leave aside banking, at least the other sectors. So, is that an issue which is still evolving, or is it?
Well, the parliament has, as of today, settled it in the sense that all that has been given to the competition commission
They've been given
for all sectors, and no sector is exempt as of today. But there is a proposal, and if parliament approves the amendment to the Banking Regulation Act, then bank mergers acquisitions will be carved out from CCI and will be handled by the prudential regulator, which in this case is the Reserve Bank of India. For the other sectors, there is no decision as yet. There have been viewpoints which have been expressed within the government that these things need to be carved out and given to those regulators. But there is no decision as yet. I presume that the cabinet or the group of ministers will take some decision one way or the other, and ultimately it will require the approval of parliament
So,
in case there are going to be exemptions.
we'll come back to this discussion after a small break. Please don't go away and keep watching Rajya Sabha television. Welcome back to State of the Economy. We are having a conversation with Mr. Ashok Chawla, Chairman of Competition Commission of India. Mr. Chawla, you just said that some of these issues which are still being resolved, and as you said, Parliament has to bring clarity on how in some sectors mergers and acquisitions and issues such as these will have to be clearly be put under the CCI's domain. The other issue that that I was looking at, again a related issue in this context, CCI also inherently has to protect the consumer interest in several sectors, right? Now recently there have some interesting judgments came from CCI in regard to some real estate companies, where I mean it's in public domain, the DLF famous DLF case, where a very interesting law point came up, where DLF tried to question whether consumer interest is that CCI's domain, or is CCI just supposed to look at competition issues? Now, where do we stand on that? Because I read some of the CCI orders, and they argued that consumer interest is indeed also part of the legal framework which CCI is mandated to handle. Where do we stand on that?
Well, the competition law and the preamble to the Act brings that out very clearly, identifies that the end goal is consumer interest or consumer welfare. But having said that, That's not really the only and the main focus of the Competition Act. There is a separate Consumer Protection Act for that purpose, which is now 25 years old. So where there are pure consumer issues, they will go under that act. But where there are issues of business to consumers or business to business, and which impact the fair and efficient working of the markets, they are within our domain, and they will, in many cases, particularly where it's business to consumer, have a bearing on consumer welfare.
Okay. And particularly in this case, I found it fascinating that it was argued by DLF that there are no competition issues because there are large number of real estate players. But the Competition Commission in turn, in one of its orders, said that there is something called relevant market concentration of power, as in I mean, real estate is not something, it's not a movable kind of good. So in a certain market, say national capital region, there could be one person, one real estate player who could be dominant, whereas they may not be dominant in a much larger geographical territory. So I found that point very interesting. Now, where has that thing got? Is there a conclusion to that? I mean, how has that evolved?
Actually, the whole principle of competition and competition law is based on these two concepts all over the world, on what is the relevant product and what is the relevant market.
In terms of geography?
In terms of relevant geographical market. So relevant product market, relevant geographic market. So you look at, in the DLF case for instance, the Commission looked at what is the product, it was high-end real estate, what is the relevant geographic market, and the Commission in its wisdom defined it as the area around Delhi or Gurgaon area, etc. In that, DLF was clearly dominant, therefore found to be abusing its dominance, and therefore the penalty.
That was the conclusion.
So the international principle of application of competition law, not just in our law but all over the world, is based on these concepts of determining what is the product which is under issue, what is the relevant geographic market.
And Mr. Chawla, another tricky issue that keeps coming up is, which is a consequence of globalization really. There are, a merger may happen outside your jurisdiction, but then it may have an impact on businesses here. Two entities merge, say in Europe, and as a result of their mergers, there could be two entities here would also start working together, and they may become dominant and they could misuse their dominance. Now, how does Competition Commission look at this? Have you come across cases of this kind?
Yes, in fact the Act provides that where there is a merger or acquisition outside the country, but it's likely to have an impact on competition within the country, and that gets onto our radar. And even though it's extraterritorial, but because the impact on the market is going to be here, it's part of our beat. But if it's not going to have any appreciable adverse effect on competition here, then we do look at it, but we don't sort of give it significance.
Now, moving back to the very important committee that you headed before you took over as Competition Commission Chairman, which was allocation and pricing of natural resources. This is the biggest, hottest debate that this country is witnessing today. How do you allocate and price spectrum, coal, iron ore? There is every one of these sectors that you see. There's a CAG report which is scathing in the way it has criticized the government in the way various governments have allocated. So not just this government. Now, what are the broad conclusion of that report that you recently concluded and submitted on allocation? How do we avoid such misgivings in future on resource allocation?
Well, the basic philosophy in our recommendations was that the process of allocation has to be absolutely transparent, because we found that it's quite opaque in many of the activities that were going on. So transparency has to be the cornerstone. The second issue is how do you price it, and there the recommendation was that by and large it should be on the principles of auction. which really is the best way to determine what the intrinsic value of that item is, which is going to be used for commercial exploitation. But in case there are areas and activities where you cannot immediately go for auction.
Yeah. Like water, there's been a debate whether you can auction
Water, for instance, or even in relation to mining, in areas where it's not very clear what is the level of reserves there.
Okay.
So you may not be in a position to auction because the persons don't know what is there. Even the government authorities will not be able to tell the prospective bidders. So in those kind of situations, it may not be appropriate at this stage to go for auction, but by and large, that's the way to go, so that there is credibility, there is no criticism, and the government gets the kind of revenue which it should be getting.
But how do you, Mr. Chawla, how do you ensure that in some sectors, suppose you may genuinely want to deliver to the consumer, let's say coal, electricity at a certain price, I don't think in this country today people are willing to pay 8-10 rupees a unit for electricity. So how does the government ensure that even while auctioning and while following transparent system, you still deliver some of these services at a price, at a reasonable price, because there are a lot of poor people in this country who may not be able to pay.
Absolutely. In fact, we looked at this issue, and our recommendation was that don't subsidize or don't mix up the pricing at the input level.
You subsidize at the
Wherever,
post output
as
level.
a matter of public policy, you may need to subsidize the end consumers. Do it there, so that part also is transparent, that part is clearly known. So if you don't want power to be sold at 8 rupees, 9 rupees a unit, you subsidize it there. But don't subsidize the inputs, because it gets into a complicated business. Nobody knows where the benefit is going and where it's not going.
Thank you, Mr. Chawla, for talking to us. It was good to have you in our studios. That is all we have in this edition of State of the Economy. We will come back with another episode soon. Thank you. Goodbye.